Hello, Colorado Realtors. I'm Scott Peterson, and thank you for joining me for another edition of Legal Bites. In today's edition, we're going to be talking about seller property disclosure, seller disclosure requirements, really, and some of the implications and aspects behind seller disclosure. And remember, this is going to be distinct from broker disclosure requirements, which is a little bit different. I'm going to address that in the next edition of Legal Bites. But for these purposes, we're going to be talking about what a seller's obligation to disclose is. So as you guys know, the first place you go when you start talking about seller disclosure is the seller's property disclosure, the SPD document, which is a commission-approved form. And it's a specific document that you're referring to or that the contract refers to in paragraph 10.1. 10.1 of the contract makes reference to the fact that if there is a date and deadline in the dates and deadlines section related to a time frame for the delivery of the seller's property disclosure, then the actual seller's property disclosure form will be delivered to the buyer by the seller. Now, remember, there are situations where some sellers don't want to deliver the state form seller's property disclosure. Certainly in the case of a REO, real estate owned or bank owned asset, maybe in the case of an investment asset where a seller hasn't even been in the property, it's been tenants in the property for many years and now they're selling the property. Other situations like that where a seller doesn't feel necessarily comfortable delivering the state form seller's property disclosure pursuant to paragraph 10.1 of the contract. Well, if you're representing a seller in that case and you need to have this discussion up front prior to the seller signing a contract, because remember, the offer when it comes from the buyer is probably going to have a date or deadline in there for the seller to provide that disclosure. If your seller isn't comfortable or doesn't want to provide the seller's property disclosure, then you have to make sure that you're countering that contract, removing the date and deadline for 10.1. Because as soon as that contract's mutually executed with a date in there for delivery of the seller's property disclosure, whether or not your seller wants to, they are going to be obligated to execute or to complete and execute and deliver to the buyer the state form seller's property disclosure. So make sure you're paying attention when you get offers and make sure you're having a conversation with your seller in those situations where they may not want to actually deliver a state form seller's property disclosure. How do you complete it, and who completes it, or the next topics I want to hit on real quickly. How to complete it is, there's nothing that disturbs me more than when I see a seller or I see a completed seller's property disclosure with kind of a straight line down through no, I don't know, or yes. Rarely, obviously, you're going to see yes, but often in the case of no or I don't know. Your sellers need to understand that these are affirmative statements. They're making affirmative representations, whether they're saying affirmatively yes, affirmatively no, or affirmatively I don't know. And I have a hard time believing that any seller can approach that document and do a straight line down through any of those categories in really a lackadaisical manner, make affirmative representations related to the condition of, or to all sorts of conditions related to the property. And so if your seller is returning that to you, I think you as a realtor need to be, as part of your duty of care, need to be challenging your seller to some degree that they're completing that thing in an accurate and thoughtful manner, because if they are going to deliver it, then it does need to be accurate and to the best of seller's actual knowledge. So that leads to the second part of this is who completes it? It's the seller. It's never the broker, never the broker. And I think most of you know that, but what I hear a lot from brokers that concerns me is that they just say, well, I'm not touching that thing. I don't even look at it. I just basically turn it over to the buyer. I think that's a mistake as well, because it gets back to the first point that when you've got a seller that is making affirmative representations in any of those three categories, yes, no, or I don't know, related to the condition of the property, they need to be accurate. Your sellers need to understand the importance of making accurate representations in that regard. So to just say, well, I don't touch it, I just turn it over, I think it falls a little bit short of what the expectation would be of you as a broker, understanding the importance of those representations that a seller is making to allow your seller to make, lackadaisical or only half pay attention to that document as they're filling it out. I get it, it's arduous, I get there's a lot of things that they need to be thinking about, but that's the point of it. That's the point of delivering that form, is that it forces a seller to really sit down and consider and contemplate elements related to the condition of the property and a lot of different conditions of the property. So certainly don't fill it out for your sellers, but also don't let your sellers make misrepresentations or make lackadaisical misrepresentations. The next thing I want to talk about is latent defects. So in the event that your seller says, hey, I don't want to deliver a seller's property disclosure, or even if they are delivering a seller's property disclosure, paragraph 10.2 of the contract mandates that a seller is disclosing any latent defects, whether that's occurring on the seller's property disclosure or by some other writing. Latent defects are hidden defects, defects that wouldn't be naturally discovered or aren't patent defects. They're not obvious defects that a buyer, upon their own inspection and investigation, would just happen to see or find. A missing ceiling fan or a dangling ceiling fan is certainly a defect, but it's a patent defect. I would still encourage disclosure or some conversation about that, but it's not, I guess, technically a latent defect in that regard. But latent defects always have to be disclosed whether or not your seller is delivering a seller's property disclosure. So if they're not going to be delivering a seller's property disclosure, they still have an obligation to sit down and consider any latent defects on the property or related or within the property of which the seller has actual knowledge, and those latent defects must be disclosed pursuant to a writing, and that's paragraph 10.2. And there's no way to strike that paragraph. It's not something that you can just put in a date or deadline related to. So always have to disclose that, whether or not it's coming through the seller's property disclosure or some other written vehicle, always in writing. So be mindful of those things as you're representing your sellers in the market. A lot of implications related to disclosures for sellers, a lot of ongoing implications for failure to disclose with regard to statutes and limitations and liability that for a seller who does not disclose something that they have actual knowledge of, ongoing liability that can go on for a long, long time. And so sellers need to be really cautious as they're dealing with this issue. As always, if you have more questions about this, the Card Legal Hotline is available to you guys as members from 9 to 12 and 1 to 4, Monday through Friday. Feel free to use it, and look forward to getting back again with you on the next edition of Legal Bites. Thank you very much.